An act against the Constitution is void. That's how James Otis Jr. put it in 1761, really the beginning of that radical change in the viewpoints of the people that made up the American Revolution for the years before the War for Independence. And that type of a view reflects the founders' view that because government is merely an agent of the people of the several states, the only legitimate laws it makes are those that are within the bounds of what the people of the several states delegated to it in the Constitution. And today I've got a bit more on these principles, which are really focusing on sovereignty or final authority and agency. But first of all, welcome and thank you for joining me here on the path to liberty. I'm Michael Boldin with the 10th Amendment Center, and this is the show for Monday, April 29th, 2024. Hope you had an awesome weekend, but let's get right to it. See if I can pull this up here. On Monday's episode discussing the law, I covered Frederick Bastiat's view, which sprang from some of the same Lockean background as Jefferson Payne, Samuel Adams, and the rest, that the only legitimate or proper function of the law is the defense of life, liberty, property, life, liberty, pursuit of happiness is how it was put in the Declaration of Independence. Let me pull that up actually here. We hold these truths to be self-evident, that all men are created equal, that they are endowed by their Creator with certain unalienable rights. And I know we've all heard this many times, but we can't repeat it often enough because we aren't living in that type of a society today, that among these are our life, liberty, and the pursuit of happiness. That to secure these rights, governments are instituted among men, deriving their just powers from the consent of the governed. So this is an affirmation that power flows from the people. Government does not have the final say over itself. There is some other power. And the Declaration goes on that whenever any form of government becomes destructive of these ends, that is, preservation or advancement of life, liberty, and the pursuit of happiness, it is the right of the people to alter or abolish it and to institute new government, laying its foundation on such principles and organizing its powers in such form as to them shall seem most likely to affect their safety and happiness. And here's how Mike Maharrey put it in an article we published over the weekend, Sovereignty and Agency, discussing these principles in much more detail than I'm going to go through here today. But Mike points out that the Declaration set the philosophical foundation for the American system of government. The people would remain sovereign and the government would serve the people. At least that's how it's supposed to be. But how is that sovereignty exercised? And he points out that in the American political system, the people of the several states are sovereign, meaning they hold final or ultimate authority. Power flows from them to the federal government, actually to any form of government, which merely serves as their agent. We can see James Iredell, who was one of the first associate justices on the Supreme Court, one of the top legal minds of the time. He was nominated for that role by George Washington, but here he is in the North Carolina Ratifying Convention in 1788. He says, "Our government is founded on much nobler principles than those in Europe, of course. The people are known with certainty to have originated it themselves, rather than the principle that government is a hereditary monarchy and it just handed off from aristocrat to aristocrat." That's how basically he's discussing. He said, those in power are their servants and agents, and the people without their consent. So he's reiterating the principles of the Declaration of Independence. You don't need permission from government to form your own new system. I mean, that kind of goes against the entire structure of things. Those in power are their servants and agents, and the people without their consent may new model their government whenever they think proper, and not merely because it is oppressively exercised, but because they think another form will be more conducive to their welfare. So the notion that of course, Jefferson in the Declaration, he's basically saying you don't want to change things long established just to do it, just on a whim, because you run through convulsions and problems and things like that. But that doesn't mean you only have the right to abolish your system, to institute new forms only when it's oppressive. You don't have to wait till oppression. You should really actually start thinking about it well in advance so you don't get to that point. And Iredell is basically making that case They can model new government whenever they think it's proper, not merely because it is oppressively exercised, because they think another form will be more conducive to their welfare. It is upon the footing of this very principle that we are now meant to consider the Constitution before us. And so that is the choice that they make. And we can see this principle reiterated in the ratification of a number of states. For example, the ratification document for the state of Virginia in June of 1788, they say they want to recommend some amendments to be added to the Constitution after ratification, but they want to include things like this. First, that there are certain natural rights of which men, when they form a social compact, cannot deprive or divest their posterity, among which are the enjoyment of life and liberty, with the means of acquiring, possessing, and protecting property, and pursuing and obtaining happiness and safety. Very similar, echoing these principles in the Declaration, going back to Lockean principles and even further back from that as well. Second, that all power is naturally vested in and consequently derived from the people. That magistrates, therefore, are their trustees and agents, and at all times amenable to them. And Meharry describes it like this. He said, this reflected the fact that the constitutional system, the structure of the Constitution itself, is at least partially, if not heavily rooted in agency law, the law of principles and agents. We certainly understand this, and I covered this in a recent episode to some degree on the necessary and proper clause, where the primary drafters of that clause, Edmund Randolph and a few others, were very top legal minds of the time. I believe it was Oliver Ellsworth as well. Basically, James Wilson, mostly Supreme Court justices. They rooted things in the notion, legal principles of principle, a principal, and an agent, someone acting on their behalf. Now, Randolph, as a quick aside, didn't think that the necessary and proper clause was actually all that awesome. He thought it was going to be abused, but you should check out that episode another time. I'll see if I can get a link to that in the show notes when I'm wrapped up here. Anyways, the government, the agent, was created to serve the people of the states and the will of the people of the states, not the other way around. Of course, they treat it the other way around today. Here from Cornell Law School Legal Information Institute. I often rip on them when they get stuff wrong, but here's just a nice overview as well. Some of the legalese is good to read there. Broadly speaking, an agency relationship may arise when one person, a principal, and another person, an agent, agree that the agent will perform certain actions on behalf of the principal, subject to the principal's control. Such a relationship may also arise when the law authorizes one person to represent another person's interests. So if you think about the original structure of the Senate before the 17th Amendment, I mean, senators are still supposed to be representing the interests of their state, but they certainly don't act like that. And James Madison, of course, warned that if the Senate was chosen in the same manner as the House, this would lead to a consolidation. So even though on paper they're supposed to be representing their states equally, the structure was made to have one chamber in Congress represent the people democratically to some degree, or at least they tried, or they claimed it was going to be, and the other ones were going to represent the interests of the state. These are actually agents of those entities, whether people or the state governments or the states as a whole. Here's St. George Tucker talking about this this notion of agency as well. He said, the federal government of the United States is that portion only of the sovereign power, so final authority, which, in the opinion of the people of the several states, could be more advantageously administered in common than by the states respectively. So the sovereign power, they're basically just saying, you can exercise this. We want you to do this because we think it's for our benefit. And that also kind of includes the notion that, well, government doesn't get to keep that power permanently. If the people want to new model things or change things, they can do it whenever they want for whatever reason they want. It isn't up to getting to permission from the government itself. And John Jay, who was the first Chief Justice, described it like this: the Constitution only serves to point out that part of the people's business which they think proper by it to refer to the management of the persons therein designated. And he continued, those persons are to receive that business to manage, not for themselves and as their own, but as agents and overseers for the people to whom they are constantly responsible and by whom only they are to be appointed. So again, they're acting as agents of the states and of the people, or technically the people of the several states. Now, Meharry says that St. George Tucker also emphasized a point that James Madison made in his very famous Report of 1800 that was defending or explaining the Virginia resolutions of 1798 against the hated Alien and Sedition Acts. And here Mike says, the people of the states' submissions to the operations of the federal government is voluntary. So, of course, you can withdraw from that. And the federal government's, quote, counsels, its sovereignty is an emanation from theirs, the states. In other words, Mike says, the only legitimate power the federal government wields flows from the people of the several states. And I know I'm hammering through this over and over and over, but it is a point that has been missed almost constantly. Of course, we've been propagandized that government gets to decide what government is empowered to do. And if we don't like what government does, we get to ask government to stop doing or start doing things that it wasn't supposed to do or was supposed to do in the first place. And we're basically, instead of living in a land of the free, we're really a population on our knees begging for permission for scraps under the version of the government-run school system the propaganda centers have fed us, and that we all kind of, I know I did, we all kind of go along with until maybe at some point our eyes are opened that the structure is supposed to be much different. Now, I'm going to link to all this stuff in the show notes, all these original source documents and articles. Meharry's article is excellent. It's a long one. I do encourage you to read all this stuff so you can learn more in context on your own time. Alan Mosley will get that organized, the blog post for every single episode, like he does, with all the different show links, plus all the different platforms we're on. We live stream on the mainstream ones. We archive all over the place. We have the audio-only podcast edition basically everywhere possible, plus the show links section, and I'll get that published in a couple of hours after this live stream is done over at 10thamendmentcenter.com/path to liberty. And while I'm here, I want to take a quick moment to say hello to everyone out in the live chat. I really appreciate you being here, whether this is your first episode or you've been here for every single one since day one. Over on Rumble, there's Gypsy and Dennis, Render and Brewster, and a few others. I appreciate you guys joining me over there. Of course, the Ron Paul Liberty Report crew joining us here for Path to Liberty. Thank you so much over on Rumble. There's also Kirk and Jug and C&T and Cheriton and M. Gabriel and a bunch of other people, Haji and a few others over on YouTube and Facebook and elsewhere. Again, thank you for being here. I know I say thank you a lot, but I cannot tell you how grateful I am to have the opportunity to do something for a living. I mean, it's not a great paying living, but it is a living. I'm able to earn a living working really, really hard at something that I'm passionate about and that I love. And the only reason I can pull that off is because of you. Without you spending time, without people being interested in what we're talking about, the work that we're doing, there's no point in the 10th Amendment Center. So thank you so much for being here. Again, 10thamendmentcenter.com/path to liberty is where you're going to find the show notes for this episode and the blog post for every single episode that we do. Now, let's look a little bit further. The notion that the only legitimate law is that which stays within the bounds of what the principal delegates or authorizes to its agent. So for the people of the several states, that's the Constitution that goes way back. And even though he wasn't the first, John Locke may have been the most influential in his two treatises near the end of the 17th century. And here, for example, he said, the power of the legislative being derived from the people, so the power to create law comes from the people who are just telling them, you can do this within these bounds. The power of the legislative being derived from the people by a positive voluntary grant and institution can be no other than what the positive grant conveyed. The TLDR, I mean, it's a pretty short one and it should be pretty clear, but the power to make law comes from the people to an agent, whatever body that may be, a parliament, a Congress, however they may have structured it. It's voluntary. They've voluntarily chosen to do it. That means they can voluntarily end that relationship. And they're only authorized to do those things that have been delegated to them in the first place. That's how James Wilson described it in his very famous State House Yard speech in October of 1787. You should read it in full. It is far more important as far as the Federalist arguments in support of the Constitution than the Federalist Papers, because the Federalist Papers were really very limited. I know they're very well written, and if you want to understand the Federalist side of things, you're going to get a lot of it from there. Thomas Jefferson and James Madison considered it essential for your learning. But certainly as far as what influenced the ratification of the Constitution, they weren't very widely read outside of New York State because it was just written for that audience. James Wilson's State House Yard speech, Terence Cox works, John Dickinson's Fabius letters, these were printed all over the place and had a lot more influence on the ratification debates. But here's James Wilson. Congressional authority is to be collected not from tacit implication, but from the positive grant expressed in the instrument of the Union. That's the Constitution. He's just reiterating this Lockean principle that the power of the legislative, the Congress, comes from the people, and they only get to do what has been positively granted in the instrument of the Union. That's it. And Meharry puts it this way. This principle of delegating only certain powers to their agent really is an affirmation of where sovereignty lies. And in practice, Mike writes, sovereignty means final authority. Whoever is sovereign in a system has the final say. They are the boss. So the sovereign part of the system is the people of the several states. We know that it comes from the people. It says it in the preamble. The preamble, Mike writes, declares where sovereignty lies, we the people. But, and I know there are some people out there who know this already, it would more accurately read, we the people of the states. In fact, Mike points out, the initial draft listed all the states. It was like, we the people of Connecticut, Delaware, etc. But the Committee of Style recognized that this would be problematic if some states chose not to ratify. So they were understanding that they were ratifying through the states. I know Brian McClanahan talks about this quite a bit. If you're not listening to his podcast or watching his show on a regular basis, the Brian McClanahan Show, you are missing out on quite a bit. He's one of my favorites, one of my most consistent ones that I personally listen to and learn from as well. And he always points out that the compact fact is how he describes it, rather than the compact theory of the Constitution, is expressed in Article 7 of the Constitution, pointing out who is in charge, who is giving the Constitution legal force. And Mike points that out as well. This is key. The people ratified the Constitution through the existing sovereign political societies, the states. The Constitution itself makes this distinction in Article 7, quote, the ratification of the conventions of 9 states shall be sufficient for the establishment of this Constitution between the states, so ratifying the same. And James Madison explained this as well in Federalist 39, points out that each state, in ratifying the Constitution, is considered as a sovereign body, independent of all others, and only to be bound by its own voluntary act. Again, these are voluntary acts of sovereign societies. Now, this isn't referring to state governments as being sovereign. The idea, and I know a lot of people tell us, states' rights, states don't have rights. And in the modern sense of the term, thinking of rights, this is absolutely correct. Now, the founding generation often use these terms rights and powers interchangeably. If I can pull up this John Jay quote one more time, I might be able to actually give you an example. No, I don't have it handy. So John Jay, actually, in the quote that I read from him a little bit earlier, he basically said government only exercises those rights that the people have delegated to it. So he's using rights and powers interchangeably. But the idea is that states having sovereignty isn't referring to a state government. And James Madison actually pointed this out in his report of 1800. He pointed out that the word state has a bunch of various definitions that depend on the context. And here's how he put it. Thus, it sometimes means the separate sections of territory occupied by the political societies within each. Sometimes the particular governments established by those societies. Sometimes those societies as organized into those particular governments. And lastly, it means the people composing those political societies in their highest sovereign capacity. So the people of the several states. And he said that it was in that final sense, the people composing the political societies in their highest sovereign capacity, that the Constitution was submitted to the states. He said, in that sense, the states, and he put states in scare quotes, states representing the people of the several states, they're the ones who ratified it. And in that sense, the term states, they are consequently parties to the compact from which the powers of the federal government result. So again, power flows from the people of the several states to their agent, the federal government, in a voluntary choice. And Mike Maharrey puts it like this. To put it in the simplest terms, it's like a 2,200-word article that Mike wrote and we published yesterday. You definitely got to read it. It'll be linked to in the show notes. But in the simplest terms, we want to TLDR it. He said, the people of the states are sovereign and government is their agent. As St. George Tucker said, federal power is, quote, not a flame by which the states have been consumed, nor a vortex in which they are swallowed up. Each is still a perfect state, still sovereign, still independent, and still capable, should the occasions require, to resume the exercise of its functions as such in the most unlimited extent. So if they want to leave, I guess it's up to them. Thomas Jefferson, of course, said, hey, if these states are not on board with what they want to do, let them go in peace. That's the mentality of the founding generation. And Mike says the bottom line is the federal government is a servant of the people of their states, their agent and nothing more. So many people treat the government as rulers over us, as people in power that we have to be subservient to until we can convince them to change their mind. And that is the mentality of, well, a subject rather than a principal. And he says, and as the saying goes, no servant is greater than the master. And as a result of this type of mentality, this view of sovereignty, agency, final authority, Mercy Otis Warren put it this way in her observations on the new Constitution, which was for many years wrongly attributed to Elbridge Gerry in 1788. It was a very powerful anti-federalist creed against ratification, but here's how she described things. Government is instituted for the protection, safety, and happiness of the people, and not for the profit, honor, or private interest of any man, family, or class of men. Unfortunately, this is not Mercy Otis Warren saying it, but unfortunately, that's the version that we have today. Government is for the control and power of a small group of people, putting the many under the domination of the few. As James Madison warned us, he said, war is perhaps the greatest threat to public liberty because war gives us armies. From armies, we get debts and taxes. And armies and debts and taxes are the known instruments for putting the many under the domination of the few. That one just kind of popped into my head there. I guess I've repeated it often enough. But again, Mercy Otis Warren is saying that the only reason government is supposed to exist, the only reason it's there is for protection, safety, and happiness of the people. And she continues, the origin of all power is in the people, and they have an incontestable right to check the creatures of their own creation. Or here's John Hancock in the Massachusetts Ratifying Convention. At the very last minute, he's basically saying, look, let's go ahead and ratify. We want to get a bunch of amendments, the first of which they recommended was a precursor to what became the 10th Amendment, this big line in the sand referring to reserved powers of the people and the states. And Hancock said to the people, look, go for it. Here's why, even if you don't agree with everything here, the powers reserved by the people render them secure. Of course, it's up to the people to actually use those powers reserved to them rather than wait to convince the government to stop doing what government was never supposed to do in the first place. And when the people have that right attitude, as Samuel Adams told us, all might be free if they valued freedom and defended it as they ought. Well, I hope you guys found this interesting. I hope it was educational. More important than anything, I hope you learned something. If you want to help us get these essential foundational principles out to more and more people, absolutely nothing helps us do this work more than the financial faith and support of our members. You can join us for as little as $2 a month. We also have annual, lifetime, and 5-year options. So if you've got a couple of bucks of that dirty government fiat, please consider throwing it our way. No one punches above their weight class better than the 10th Amendment Center. Or at least that's what Edward Snowden's attorney told us a few years ago in a meeting that we had with them in New York, dealing with some state-level privacy things. Side note, maybe I'll tell that story in more detail one of these days, but we punch above our weight class. If you want to help us take a stand for the Constitution and liberty, whether the government likes it or not, which they certainly do not, please consider joining us over at 10thamendmentcenter.com/members. Again, I really appreciate you being here. I hope you enjoyed the episode. I'll take a look over the live chat and the comments a little bit later today or tomorrow. Get a lot of great ideas for future episodes from your comments. You can also email me, team@10thamendmentcenter.com, all spelled out. I don't get a chance to reply to everything, but I certainly do read through a vast majority, if not all of it. So I'm very grateful for your support and your help. And I'm going to keep saying thank you for being here. And if you also want to think of a few other things that you could do to help us spread the word, taking actions, especially on the mainstream platforms, can help trigger their algorithms and tell them, hey, this is an interesting show. A lot of people are commenting on this, liking it, leaving reviews on Apple Podcasts, etc. Will oftentimes get those platforms to deliver our show into the faces of more and more people. So however I'm not eloquently putting that, I'm very grateful for any help you can give us to spreading the word today. Thank you again for being here. I hope you enjoyed the episode. Hope you had an awesome weekend, and I hope to see you next time here on the Path to Liberty.